Welcome back to Winning Isn't Easy. When workers' comp records can help or hurt your ERISA claim. Now, I've set the stage in the first segment of this podcast. So let's talk about when workers' comp records can help or hurt your claim. And this can get complicated. It can be complicated because there are things in your workers' comp file that can hurt you. I'm working on a workers' comp case right now where we're fighting about money, medical benefits, and medical treatment, including whether my clients should undergo a functional capacity evaluation. And we refuse because the carrier is using a liar for hire FCE provider who I know is going to say my client can do things that they can't do. Now, the carrier has denied the claim, and I'm looking at the adjusting notes and I'm seeing nasty things about my client, about them having surveillance on her, about communicating with the treating physician, getting that treating physician to agree that there should be a functional capacity evaluation with their liar for hire evaluator. Now, what would happen if this particular case bled into a long-term disability case? Ultimately, here in the context of the comp case, they're going to take the deposition of my client. I'm going to take the deposition of the adjuster. I'm going to take the deposition of all the doctors involved in the case. So if this case is one in which my client also had an ERISA disability claim, what, if anything, is going to be presented to the long-term disability carrier? What would be helpful or not helpful? And what should be done to protect yourself? Now, I will tell you that some people think everything should be thrown in like into the kitchen sink, and it all kind of washes out. Some people say, not quite so fast. Now, obviously, they're going to have opinions of work comp doctors that are not really favorable because comp doctors don't get paid to give favorable decisions. We're going to have my favorable IME, for example, in my case, and then they're going to have the testimony of any other person that they want to talk about how, my client is not a really nice person and shouldn't be listened to. So as a general rule, I find that unless your claim is denied, you're not going to have access to what's in the disability carrier file or the peer review reports. And as a result, you're not going to be able to understand why they are setting up your claim for denial. So they're going to get peer review reports from liar for hire doctors looking at your medical condition that conclude you're not disabled, that you don't have the restrictions, that you can do your own occupation. And then there's this tension, if you will, back and forth between both the comp carrier and the ERISA carrier, because they're all looking for reasons to deny the claim. Now, if your work comp file is full of evaluations that say there are no objective findings on examination, that you can work, that your diagnostic studies are unremarkable, that you're exaggerating, like in this case, potentially those are kind of things I don't necessarily want the disability carrier to see. Would you? Now, on the flip side, if you've got a doctor who is a good treating doctor or a work comp doctor who says you've got permanent restrictions, conditions unlikely to improve, a good IME report, that's the kind of stuff you want to put in your ERISA disability file. So what happens here? Well, my approach is that we have control over what's submitted, at least initially. We do have a duty to cooperate. And unless they ask for the comp material, I'm not going to supply it to them generally unless it's particularly favorable. I understand that if I submit stuff, they may ask, well, we want to see the entire file. And at that point, then I have to make a decision about the extent to which I'm going to cull and the extent to which I'm not going to cull the work comp file. Because obviously, as an officer of the court, I also need to make sure that I'm meeting my ethical duties. And you, as the policyholder or plan beneficiary, need to make sure that you are cooperating pursuant to the terms of the policy. So you can see that there is this tension that goes back and forth. What I try to do is submit documentation in a format that explains why the comp material aligns with what's happening in the long-term disability claim. As I said, if it's not favorable, I'm not necessarily submitting it because I don't necessarily have, in my view, a duty to submit it to the disability carrier plan unless I'm asked. Once I'm asked, then obviously I have to abide by the rules of ethics that govern my conduct to make sure I'm not violating my ethical responsibilities. So what I decide to do is in part a product of what the policy requires, what the carrier is asking for, and what my discussions with the work comp attorney is revealing. They may not have the entire file, or I may not have the entire file, so I can potentially produce what it is I think they want and what I think aligns with the ERISA disability claim. And again, consistent with the rules of ethics. So the question as I see it is this. I have never seen a work comp carrier ask for any material from the long-term disability carrier. So that's pretty easy. But what I do see is it the other way around. In other words, the comp carrier the ERISA disability policy or plan has the right to an offset for your workers' comp benefits. And they may ask, they may be happy that they're paying benefits and they don't really want to see anything because they get the offset. But there are some times that they may say, well, you're not getting the comp benefits anymore because benefits, were terminated. What's going on? We want to see the file and we want to know if the case has been settled because, again, we continue to have an offset. Now, one of the other things that you need to understand is what is admissible in the context of a workers' comp case. There are times when I will supplement or give to the work comp attorney a work comp claim with the attending physician statement forms just to show continuity of treatment. But that is not necessarily going to be admissible in the context of a workers' comp case. So your doctor will say something really nice about you in the APS forms because they're your private treating physician, which is contrary to what the workers' comp doctor has to say, who doesn't, who knows where his bread is buttered. In that context, I certainly do try to supply it to the comp attorney, to the comp carrier, but you need to understand, for example, it may not be admissible in the context of a workers' comp case. Here in Florida, only the opinions and records of a treating physician, an authorized treating physician, an expert medical advisor, or an IME are admissible. So while you might have records from a private doctor potentially admissible for the purposes of history, none of their opinions are going to be admissible in the context of the workers' comp carrier. So in this example where the private treating doctor saying really great things and the comp doctor says nasty things, the opinion of that private treating physician may not even be admissible. So you've got to understand your state workers' compensation law. So I guess the bottom line here is to try to figure out what's going on in the context of the ERISA disability claim, in that you need to understand what the policy or plan requires that you produce. You need to understand, does the carrier have the right to an offset? What kind of information are they asking for? Is this information that obligates me to provide the entire file, or are they asking for certain kinds of things? We generally will work with a work comp attorney and trying to figure out and sort this out, looking, of course, at the policy terms and what the carrier is looking for, the ERISA carrier is looking for, and kind of sort our way through this. It's a troubling scenario, and there really isn't a clean answer. I think it's really fact specific. And again, one where you want to try to sort of give them what they want, but give them what they want, if you will, in a fashion that helps your ERISA disability claim. Got it? Now we're going to talk about the flip side where they hide the ball. Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.